I'm Ann Neal, President of the American Council of Trustees and Alumni, and we are just delighted to have you here today for our conference, Free to Teach, Free to Learn. I think it's a glorious setting, if I do say so myself, and just pleased to have with us so many wonderful experts and others interested in this issue of academic freedom and the free exchange of ideas. I think most of you are familiar with the American Council of Trustees and Alumni, but I want to just spend a few minutes talking about us. We have been around since 1995, and we were created essentially to help trustees find an independent resource for their work so that we could empower them in their oversight role and provide them with the information they need to do their job. As an organization, we issue a number of reports each year, and we are basically focused on solutions. We like to outline problems, but we also like to point those who have the ability to make change to ways they can do so. And you will see in your booklet today that we have a range of pages focusing on action steps for trustees in the area of academic freedom. We abide by the 3 A's at the American Council of Trustees and Alumni: academic freedom, academic excellence, and accountability. And we will be addressing all of those topics in the course of today. I guess the larger question also is, well, why are we here? And I think we are all here today because we know and appreciate that academic freedom and the free exchange of ideas are essential hallmarks of a quality higher education, but that in too many respects, these concepts have become abused and confused. We see egregious violations of student and faculty First Amendment rights. We see hundreds of speech codes, universities which disinvite speakers, classrooms where students are indoctrinated, departments where students can't get certain kinds of courses, orientations which often verge on mind control, student associations which are forced to accept students who do not agree, and faculty who have difficulty pursuing certain subject matters in order to succeed. So we're going to be addressing these issues in the course of the day because it's our contention that the failure to understand and defend academic freedom is undermining the public trust in American colleges and universities. And regrettably, organizations such as the American Association of University Professors, the traditional defender of academic freedom, has become part of the problem. As you look today at many of the interpretations by the AAUP of the 1915, 1940 statements and others, there is a much greater focus on perks and privileges than there is on correlative rights and responsibilities. And you'll find that the experts who've written some remarkable commentaries for our booklet today point out this particular problem time and time again. But as I said, we believe in solutions, so we are delighted to be focusing our book on trustees and informed leaders who, quite frankly, far from being enemies of academic freedom, which you will find in some of the earlier statements, they are rightly called out as disturbing academic freedom. We feel that today, in fact, they are the answer to ensuring academic freedom. And if I may, in this wonderful building dating back to 1863 in this club, we will call trustees the last best hope to defend academic freedom and free expression. Now, you have before you a booklet hot off the presses, terrific new commentary written exclusively for us by Larry Summers, Judge Jose Cabranes, Harvey Silverglate, Alan Charles Coors, Philip Hamburger, Neil Hamilton, and Donald Downs. And we are delighted to have the latter three with us today, who will be talking about what they have written and engaging us throughout the day. Our goal here is to have a candid, I suspect a provocative discussion of these issues, and we're also pleased to have with us Greg Lukianoff, President of the Foundation for Individual Rights in Education, which itself does a remarkable job in dealing with speech codes and other inhibitions of free expression on our college campuses. I want to thank you all for coming. We're very fortunate to have you in the audience. Trustees on whom the responsibility relies to protect and defend academic freedom, education leaders. We have amongst you some of you who have actually lived through the case studies that we're going to be discussing today. And we know some of you, you are new to us as well, and we look forward to hearing more about you during the lunchtime. We are also extremely grateful to the Ewing Marion Kauffman Foundation and the Bodman Foundation for their support of this conference. I want to acknowledge Russ Penoyer and John Krieger, who are with us. Thank you so much for making this possible. What will we do after today's conference? This booklet that you have before you will be sent to more than 10,000 college and university trustees around the country. And we also will be having a video of the panel discussion and our keynote so that we can make that available to trustees around the country who are interested in this topic. I'm also very happy to say that Wall Street Journal online television is going to be featuring Benno. He's going to run over during the lunch hour to talk about this conference with them. I also want to acknowledge Rachel Wildowski, who is with us. She has been the project director for Free to Teach, Free to Learn, and we're grateful to her for all of her efforts. So prepare yourselves for a day of education. We're going to start with a keynote. We'll go into a panel discussion, questions and answers, and case studies throughout the day, which will be led by our distinguished professors. I really want you to think that you're back in college. We're going to work through these case studies. We want to encourage questions and answers. No question is dumb in this forum. And then at video, we also are going to have at lunch. We'll, I think, get your juices flowing, and after that, we'll have an opportunity to have you introduce yourselves. So with that, I'm going to turn this over to Benno Schmidt, who I must say is a real hero in the American Council of Trustees and Alumni's book. We all know he's a First Amendment expert, former dean of Columbia Law School, an academic entrepreneur extraordinaire, board chairman of the City University of New York, which under his leadership has just done remarkable things in terms of quality and affordability. He is truly the model, engaged, and thoughtful trustee. And we were very, very honored to present him the 2011 Merrill Award for the Advancement of Liberal Arts Education for his work on behalf of quality higher education. And I should note, he is also an acclaimed performer in 2 Woody Allen films. So with that, I want to turn it over to Benno. Thank you so much, Benno, for being with us.
Thank you, Ann, and it's a pleasure to be here, and I'm honored to have the opportunity to kick off this important discussion. What do we mean when we call for academic freedom? What is its legitimate and legal domain, its legal status? And when is this important concept simply being abused? The freedom to teach and to learn, the freedom of thought to challenge widely held beliefs and to speak one's mind, these are, of course, indispensable attributes of any quality education. Professors must indeed have substantial independence from political pressure or economic leverage to seek the truth wherever that may lead. And surely students have a right to a classroom experience that will prepare them for informed citizenship and that exposes them to a robust range and exchange of competing ideas so that they can learn to evaluate evidence and arguments and come to their own thoughtful, independent decisions. And yet a failure to understand these concepts and to defend them is undermining public trust in our colleges and universities, harmful to the long-term health of these institutions. As I outline in my foreword, the very groups that have been charged with protecting and advancing academic freedom are often part of the problem. They violate several classic maxims of the law, such as no one should be a judge in their own cause, or whoever seeks equity must do equity. Academic freedom is a privilege that can be lost, and it is in fact on many campuses in jeopardy now, and its wounds are for the most part self-inflicted. As Anne said, professional organizations such as the American Association of University Professors and the American Federation of Teachers are embracing an expansive definition of academic freedom that emphasizes rights and privileges, job security, collective bargaining options, but has significantly less to say about accountability and responsibility. They seek broad protection for the free expression of the professoriate inside and beyond the classroom, but have nothing to say about egregious violations of the First Amendment and academic freedom of the students on their campuses and in their classrooms. ACTA realized long ago that trustees, as fiduciaries, are ultimately responsible for ensuring that their institutions are open places, open to the free exchange of ideas and places of academic freedom. And as Anne said, this conference and this booklet that we've put together are designed to help trustees and everyone who is interested in education more generally to understand academic freedom and intellectual freedom more broadly so that it can be protected. As in the past, as you can see from the 1915 AAUP Statement of Principles, which is the first text that we have reproduced in the booklet, trustees have often been viewed as enemies of academic freedom. I hope that this conference and this trustee guide will turn this history on its head and empower trustees to ensure and protect academic freedom as faculty or others may on occasion undermine it. Free to teach, free to learn offers immensely valuable food for thought. It takes key documents, brings together a remarkable range of experts in this field, many of whom are with us today, to analyze these key documents. Let me share a few points of view on which our discussions today will focus. The 1915 Statement of Principles, the founding document of the AAUP, articulates a vision of academic freedom that lays significant burdens of professionalism and ethical behavior on the professoriate. Larry Summers warns us that we have now come to the paradoxical moment when some of the dysfunctional applications of academic freedom that the authors of the 1915 document feared have created problems that are greater than any lack of academic freedom on campuses. Neil Hamilton comments on the 1940 AAUP Statement of Principles, which is today incorporated into many employment contracts with professors. Professor Hamilton expresses a concern similar to that of Professor Summers. The professoriate have done a poor job of inculcating the ethics of the profession. Interest in autonomy, job security, and personal advantage have too often replaced the duties that justify academic freedom. Philip Hamburger's gloss on the AAUP Statement on Corporate Research points out that the sharp focus on the ostensible danger of corporate sponsorship and support for faculty research exaggerates its significance while underestimating the potential of overzealous enforcement of conflict of interest policies to suppress important elements of intellectual freedom and individual faculty prerogative. Richard Garnett comments on the Supreme Court case Garcetti versus Cabellos and cautions trustees and administrators in the wake of this case to distinguish between the appropriate supervision and control of employees on the job speech and unjustified dangerous intrusions into the academic enterprise. He argues that faculty participation in institutional governance and in debate about the university's policies and practices should be protected. My old friend Judge Jose Cabranes and Kate Stith Cabranes comment on the Woodward Report issued at Yale in 1975 by the great historian, my late friend C. Van Woodward, which still, I think, is the most eloquent statement of academic freedom of which I'm aware, which talks about the difficult but critical importance of putting free speech values ahead of such values as civility and good companionship. Evoking one of ACTA's key themes, the authors remind trustees that it is their duty to be vigilant and to defend free speech on campus, even if that speech is, in the words of Justice Holmes, the speech we hate. Alan Charles Kors, co-founder of the Foundation for Individual Rights in Education, warns us of the level of repression now seen on hundreds of college campuses. He shows how speech codes represent an affront to the very essence of academic freedom, as well as the way in which they are used to enforce ideological conformity and other agendas. His colleague, Harvey Silverglate, also a co-founder of FIRE, offers an excellent exposition on the Chicago Calvin statement, another statement by an old First Amendment friend of mine, Harry Calvin, and calls for universities to remain neutral when it comes to political and socio-political battles of the day. De Tocqueville warned us of the danger of what he called soft despotism in America, a danger which, it seems to me, is very much alive in many colleges and universities. We're glad to have the current president of FIRE with us today, as Ann said, Greg Lukianoff, who will be helping us with the case studies. In 1993, the American Scholar essay, excerpted in the booklet, by Edward Shills, distinguished professor at the University of Chicago, asked the question, do we still need academic freedom? 20 years later, Don Downs from the University of Wisconsin answers, as Shills did, with a resounding yes, but with the same warnings that it will only last if the academy rediscovers the responsibilities that go with academic freedom rights. As I look at the commentary, there are many areas of agreement. One is surely that the broad principle that freedom to teach and freedom to learn are essential parts of any education of quality. All agree that properly understood, academic freedom is an essential right and responsibility, but that it is also a prescribed right and responsibility does not mean anything goes, or as Professor Summers reminds us, that it is freedom from judgment or criticism, or that all claims are equivalent. Most of our commentators agree that academic freedom is under threat. All agree that the threat rarely comes from trustees or administrators, but more often from, again I quote Larry Summers, from inside the academy. Quote, "It is hard to credit the argument that today extramural forces of any scale prevent the faculty from publishing or teaching their ideas. On the side of insufficient academic freedom, the threat today is less from overreaching administrators and trustees than it is from prevailing faculty orthodoxies that make it very difficult for scholars holding certain views to advance in their fields. The commentators further agree that academic freedom is too often invoked in situations where it is irrelevant or simply opportunistic. Silverglate and Summers both agree that administrators and trustees must prevent the use of the university to advance an ideological agenda, whether that takes the form of demanding civility, so-called civility pledges, as happened at Harvard, or to take another example from Harvard, demands that the university divest stock in any company doing business with Israel. Downs compares faculty professional groups to guilds that forget or downplay the obligations that legitimated the grant of academic freedom in the first place. He properly notes that society has tolerated this shift until social and economic forces have compelled reconsideration, and he believes that if higher education loses control over its destiny to outsiders and politicians, it will be to a great extent because the faculty have failed to live up to their academic responsibilities. Hamburger further calls upon universities to be much harder on themselves when it comes to research disclosure, arguing that there is, and I quote, a need to require universities to report their funding and funding conditions to their faculty. Hamilton concludes that in contrast to the sister peer review professions of law and medicine, the professoriate tends not to study its own ethics and makes almost no effort to acculturate graduate students and new professors in the duties and responsibilities of the profession. To the extent that they commentators are in agreement that conflict of interest policies should apply equally to all funding and not discriminate against one type of funding or one type of conflict over another. And to the extent that they address widely prevalent speech codes, all are in agreement. All of them call for their elimination. The sad fact pointed out by Fire is that a majority of colleges and universities today have speech codes, producing a Kafkaesque world where students and faculty also have less academic and First Amendment freedom than does an ordinary citizen talking in the grocery store. There is general agreement that the Supreme Court has been sending conflicting signals on academic freedom. Commentators note that on the one hand, the court has singled out academic freedom as a special interest, yet more recently in Garcetti versus Caballos, the decision left many courts confused and allowed to believe that the government's efficiency-based reasons for controlling public employees' job-related speech may justify curtailing the academic freedom of scholars and teachers at state-funded institutions. CLS versus Martinez, another Supreme Court case, which has prompted a number of institutions to develop so-called all-comers policies, will be one of our first studies this morning. In that case, in the name of the First Amendment, the court has effectively, in practice, limited the freedom of association and free exchange of ideas on our campuses. Where are our commentators at odds with one another? Summers calls for greater transparency when it comes to the influence of corporate and other money on scholarship, expecting professors working in controversial areas to acknowledge their funding sources as well. As I read him, Hamburger is a good deal more forgiving of his fellow professors. He believes they are independent agents, albeit he would make that a rebuttable presumption. And he believes that universities should let faculty decide for themselves about any conflicting interests in the course of their own research. He admittedly says when faculty falsify data or engage in fraud, they ought to be fired. But otherwise, he would like to leave the question of conflict of interest unless they are working on a university-sponsored research project, to the faculty themselves. Hamburger contends that when a university requires its faculty to notify it of their research conflicts, it usually reduces them to agents in the conduct of their research rather than independent researchers operating in freedom. Summers, in turn, argues that the existence of a large number of competing institutions means that even if a perspective is discriminated against in one place, it has a good chance of being supported in another place. And so all views are, in the end, likely to be heard, even if not from within all institutions. I would surely argue that this is a very debatable proposition, since it seems to focus on faculty who are mobile and not on the majority of faculty and students who are in fact trapped in institutions, many of which fail to foster the robust exchange of ideas. Where do we need more thinking? The issues that Van Woodward confronted in 1975 are with us still in even more numerous manifestations. Judge Cabranes observes that when administrators condemn what they think of as uncivil or unpopular speakers and bar them from speaking on the campus, they are blurring the line between educating the community and imposing censorship. Free speech is the loser. Van Woodward rightly feared that the growing university commitment to civility over academic freedom and freedom of thought. But the soft despotism is not so soft when it has behind it federal regulation. Tocqueville was surely right. Enforced conformity places citizens in a kind of perpetual childhood. What remains, he asks, but to spare them all the care of thinking? We see now the development by government agencies of broad conceptions of their enforcement of anti-discrimination laws, which create greater incursions into freedom of expression with inevitable chilling consequences for teaching and learning. Looked at more broadly, we need to think through the evolution of academic freedom and its connection to tenure. As Ed Shills noted, and as you see from the 1915 AAUP statement, it's not surprising that job security and academic freedom seem inextricably joined. But Hamilton properly emphasizes that the tradition of faculty self-governance is what makes academic freedom unique and not tenure, as is often assumed. Summers calls for rethinking tenure as the foundational principle of academic freedom because, as he said, it makes it virtually impossible to remove professors for cause except in the most egregious cases, and threatens the dynamism of the American university. The question of whether academic freedom can be protected without tenure is worthy of continued serious consideration. Will we have an American academy full of vibrant and robust discourse, fearless in exploring, as Van Woodward put it, the new, the provocative, the disturbing, and the unorthodox? Tenure is yielding, largely on issues of finance, to reliance on adjunct and brief at-will appointments. The old argument that job security is the linchpin of academic freedom, if it were ever true, is largely irrelevant to this growing army of adjuncts on our campuses. In its place, we need to develop habits of academic freedom writ at large in the culture of the campus that is anchored in a deep sense of responsibility and enforced by vigorous peer review that must be stronger and more continuing than ever before. This conference is about how trustees and policymakers can help make that happen. Thank you very much. Could you just give me an example?
Well, I'm from Wisconsin, I'm Don Downs.
Yep.
And a year ago, a guy from Washington State developed a study on affirmative action and its negative consequences on campus, Roger Clay. And Lee Hansen, who's a colleague of mine, part of my academic freedom group at Wisconsin, brought him in to give a talk, and he did a press release down at a hotel downtown. And students literally crashed the event, threatened violence, having police on hand. The event wasn't able to be finished. And this movement by this group was led by our dean of students.
Oh, well, that's out, yeah.
She was involved in it, at least advising the students, as well as another administrator. There's one example.
Well, when I was president of Yale, I wrote about an egregious case of what the Supreme Court called the heckler's veto, when a hostile audience makes it impossible for a speaker to speak. In this case, it was, the speaker was Louis Sullivan, who was then the secretary of HEW, and Larry Kramer, old friend of mine, who's a group of AIDS agitators, broke into the speech and, just as you said, made so much noise and created such an atmosphere of threat and incipient riot that Sullivan was not able to give his talk, not able to be heard. And I said then that I viewed the shouting down of an unpopular speaker as no different than an effort to go into the Yale library and pick unpopular books off the shelf and burn them. And that I would defend uncivil speakers or unpopular speakers with the same vigilance as I would defend the library from efforts to burn it down or burn certain books, unpopular books down. After all, we had Hitler's Mein Kampf in the library, and we'd be a poorer institution if we didn't. And we need unpopular speakers. At Yale, General Westmoreland was not permitted to speak during the Vietnam War. It was a disgrace. It was the event that led to the Woodward Committee, which criticized Kingman Brewster in very vigorous terms for his part in that whole effort. So, of course, administrators are not in any way always the source of the kind of problem that we've been mentioning. But when the problem is more ideological conformity, the refusal to permit intellectual diversity in academic areas, the tendency of certain professors to want to appoint only people who mirror their own ideologies and point of view about controversial subjects, that's something where I think administrators have just been much too inert, where they need to be more active, because you do see this tendency, probably a natural human tendency, want to replicate yourself all the time. But this is why so many campuses, if you go into the Department of Near Eastern Studies, you get a completely one-sided view of things. And that, of course, that's not the only area. Now, this raises immense practical questions in trying to ensure intellectual diversity, but the principle is surely at the heart of academic freedom. And we're getting on with getting a little behind schedule. Why don't we turn to the case studies? Thank you all.